A landlord rejected a tenant receiving a public housing subsidy because of an economically disadvantageous provision in the standard form lease provided by the subsidy program. The Massachusetts High Court considered whether the landlord discriminated against the tenant in violation of state law in the 2007 case, DiLiddo v. Oxford Street Realty. Lori DiLiddo, who was disabled in a car accident, qualified for a temporary housing subsidy program for non-elderly, low-income people with disabilities. The program provided a standard form lease for all landlords and tenants participating in the program to sign. One provision of the lease said that tenants were free to leave after giving 1 month's notice if they qualified for another housing subsidy program or found suitable permanent housing. In May of 1998, DiLiddo looked at an apartment in Cambridge, Massachusetts, and expressed interest in renting it from Oxford Street Realty. At first, Oxford agreed to rent DiLiddo the apartment, but Oxford soon changed its mind after reading the form lease it was supposed to sign. Specifically, Oxford objected to the 1-month termination provision on the ground that it was unreasonable and excessive. In a lawsuit filed in Massachusetts State Court, DiLiddo argued that Oxford had discriminated against her in violation of state law. The trial court entered summary judgment for Oxford, and DiLiddo appealed. The Massachusetts Supreme Judicial Court transferred the appeal from the Intermediate Appeals Court to itself.